we need to restore our control over it, especially for those of us who give up our personal data. Uh, we've seen articles in Wired magazine talking about data being the new oil of the digital economy. And in The Economist talking about how data is giving rise to a new economy. And that's because data is being monetized, as being used to create new efficiencies, new services, or new markets. And so given how important data is, given its new role in today's data-driven economy, it really behooves countries to ensure that their citizens are protected from profiteers and those who would like to take advantage of unsavory data collection practices. And so this is Republic Act 10173, which heralds the entrance of the Philippines into the community of nations that now have legislation protecting personal data. One thing unique about the Philippine law is that this applies to the public sector as well as the private sector, whereas in other countries, their legislation is primarily intended for the private sector. The same law also created the National Privacy Commission in order to implement the provisions in the Act. Because the title is so long, a short title was given. It's known as the Data Privacy Act of 2012. The primary impact of the Data Privacy Act is that it gives these 8 rights to all data subjects. The right to be informed anytime they provide their information to banks, telcos, hospitals, schools, hotels, what have you. They need to be informed, or they should be informed of what data is being collected, why it's being collected, how it's going to be protected, who it's going to be shared with, how long it's going to be kept. And if they have any objections to this, then of course they have the right to object. They also have the right to access any information that's been collected about them and to correct it if anything is wrong, or even to have it blocked or removed if such data was illegally obtained. The Filipinos also have a right to access this data in an electronic format that's called the right to data portability. And if any of these rights have been violated, then they have the right to lodge a complaint and even to ask for damages in order to be indemnified from any harm that was caused by the use of inaccurate or illegally obtained data. Take note that these rights came into existence in 2012 when the law was signed, and therefore, when these rights were given, it also gave rise to obligations on those who collect and process this personal data, or PICs, or personal information controllers. These rights must also be respected by PIPs, or personal information processors, who process the data on instruction from the PIC. Finally, the obligations also apply to joint controllers or external entities that are using the data for a different purpose. And while the data subject and the PIC are covered by what we call the privacy notice or the consent form, 2 different legal documents would cover the external entity, and that would be called the data sharing agreement. In some jurisdictions, that's called a joint controller agreement. Whereas the PIP is covered by what we call a service level agreement or an outsourcing contract. So these obligations are contained in sections 11 to 21 of the Data Privacy Act. And so this box in yellow contains really the primary provisions, that I believe we should all be familiar with, because these are where our rights are given to us, and these are where the obligations of PICs and PIPs are spelled out. But of course, it also helps to read sections 1 to 6, because that's where the definitions are, what does personal information mean, and what is a different class of information known as sensitive personal information, plus who is a PIC, who is a PIP, who is a data subject. Those are all defined in sections 1 to 6. The scope is there as well, and the exceptions. Sections 7 to 10 cover the creation of the National Privacy Commission, as well as the functions and powers of the NPC. Sections 22 to 24 are specific to government, because government is the largest collector and processor of data in the country. And sections 25 to 37 contain the penalties. And oftentimes this is what people read first, because it's a sudden realization that, if I violate the rights of someone, if I abuse the data that I've collected from him, if I improperly dispose of it, or if I process it in an unauthorized manner, or disclose it maliciously, this can actually be punished. And so let's take a look at sections 25 to 37, because this is where we see the jail term and fine, which may apply to any violation of these provisions in the Data Privacy Act. So as we can see, unauthorized processing is punishable by 1 to 3 years if it's personal information that's being processed, and 3 to 6 years if it's sensitive personal information that's being processed. And that's why it really helps to read the definitions on what PI is versus SPI. Now, take note that unauthorized processing can happen in many cases, in many situations, simply because we forget, what we've promised to the data subject. In fact, a full 40% of the complaints that are currently being investigated by the NPC are related to unauthorized processing. For example, if you say in your privacy notice that I will retain your data for 5 years, and then 6 or 7 years later you are found to be still processing that data, then you could already be guilty of unauthorized processing. The next section, 26, is allowing access to personal information due to negligence, punishable again by 1 to 3 years for personal information and 3 to 6 years for sensitive personal information, plus, of course, a fine. And this is something that, for example, COMELEC Chairman Andy Bautista has been charged with, Section 26B, because it covers sensitive information. And by the way, there's also Section 35, which says that when at least 100 persons or more is harmed, affected, or involved, then you get the maximum penalty. So in this case, that would be 3 to 6 years found under Section 26. Improper disposal of information or using information for unauthorized purposes are also punishable, as well as breach-related offenses like hacking into a system or concealing the fact that your system has been hacked into and that personal data has been disclosed to unauthorized persons. Those are punishable acts. With regard to disclosure, the law makes a distinction between malicious disclosure, where you disclose information in order to harm someone, or unauthorized disclosure, where you could do it accidentally, or you could do it for profit. But either way, if you're not been authorized to disclose that information, then it's punishable as well. So if we take a look at the judgment that the NPC handed down on COMELEC Chairman Bautista, there's actually some text, which is on your screen, which says that, for example, the Commission found the COMELEC liable for multiple violations of the Data Privacy Act, and Chairman Bautista specifically is recommended for prosecution per Section 26, because the statement here is that to impress upon everyone that the decision is based on the fact that we expect the head of agency or the CEO or the chairman to implement proper security measures. In its decision, the NPC underscored Bautista's lack of appreciation that data protection is more than just technical or security measures. It also includes implementing physical and organizational measures. So the mistake often made, which is to delegate data privacy to the IT group or the computer information security group, is a mistake that should not be repeated. The NPC document, further stated that this disregard of his duties as head of agency is tantamount to gross negligence. The lack of a clear data governance policy unnecessarily exposed the information of Filipinos to unlawful access. So therefore, it's important to realize that, who is liable according to the law? Well, Section 22, specific for government agencies, says the head of the government agency should be responsible for complying. But for private sector companies, it also helps to read Section 34, which says that anyone who participated in the crime, therefore anyone who did the improper disposal or the malicious disclosure, of course, shall be liable. but also anyone who by their gross negligence allowed the commission of the crime. So if you're a member of the board of directors or the executive management team, and based upon the requirements of the law, these were neglected and nothing was done about putting in place the right policies and measures, then quite possibly these executives or these directors may be found to be grossly negligent and thus liable in that same improper disposal, malicious disclosure, unauthorized processing, or whatever the case may be. So it's not that difficult to comply. Now, I'm now showing you the website of the National Privacy Commission, where on the left side of the screen, if you want to know more, you can download the circulars, advisories, and even the Data Privacy Act and IRR. And on the right side of the screen, if you want to file a complaint, there's also a way to do it there. But right here in the middle, there are these 6 boxes which describe what are the 6 things that you have to do in order to comply with your obligations under the Data Privacy Act. And let's begin with the first one, which is to register. The IRR says, that the Commission requires the following: registration of personal data processing systems operating in the country. So if you have a system that gathers, that collects, that processes, that discloses or shares any kind of personal information, then you need to register that with the NPC. And that's described in Circular 17-01. And the circular actually says that mandatory registration is needed if you have at least 250 employees, or you handle at least 1,000 records involving sensitive information, or your systems do automated decision making, or you belong to any of the following 12 sectors: the government, education, healthcare, banking, BPOs, pre-need, direct marketing, loyalty programs, and so on, or you provide service to one of these. So that's quite a large swath, of the population. If you're not sure that you're covered by mandatory registration, please go ahead and register anyway, because voluntary registration is also appreciated. And there are benefits to registration. You'll be informed of the latest circulars and advisories. You'll be informed if there are extensions in deadlines. You'll be invited to the seminars and events where you can learn much more about many of these compliance obligations. Contents of registration are quite simple: the name and contact details of the PIC or PIP, as well as the DPO, the purpose of the agency or entity. As you can see, I've crossed out C and D because that's not needed as of now, but may be needed in the future. And for letter E, just a brief description of what kind of data processing you're doing: the name of the system, why you're doing it, whether you're doing it as a PIC or PIP or both, etc. So including letter F, any notification regarding whether these systems are doing automated decision making. The second compliance obligation is simply to appoint a data protection officer or a DPO, someone who can lead your compliance efforts. This is, of course, in the Act itself, which says that the PIC should designate an individual or individuals accountable for compliance with this Act. And further, there's an advisory that's been issued on what are the qualifications, what are the roles, and so on of data protection officers. One should really select the DPO based upon the level of risk that they're facing, whether it's low risk, medium risk, or high risk. Because you have several options. You can have a full-time DPO or someone that's doing a double hat role, playing another function within the organization. I know that some schools, for example, have actually formed a team or a committee, and banks have even gone to the extent of forming a full-blown data protection office. There are a list of roles and responsibilities that a DPO must perform, and these are A to I. However, there is an option also to have compliance officers for privacy, or COPs, who need to carry out letters D to I, and these are of course contained in the advisory. Now, complying with the DPA is not the role of just one person. That's why we've listed down the things that top management, HR, IT, the legal and the process owners have to do. And these are all basically playing a support role to the DPO. Being a DPO is not an easy task, and that's why companies like TÜV Rheinland have tied up with the NADPOP, the National Association of Data Processing Officers in the Philippines, or rather Data Protection Officers in the Philippines, to come up with a DPO certification program, which is a 5-day program. As you can see, the agenda is here. And those who pass the program and pass the examination get this signet, an ISO certification from TÜV Rheinland, valid for 3 years. And that QR code, once it's scanned, will actually show your certification in the Certipedia database of TÜV Rheinland. This is offered every first week of the month, and it's a 40,000 peso course. And at the end of that, as you can see here on page 5, you do have to pass the 2-hour exam. But really the cachet of having been certified as a DPO is something at least that would help to prove your credentials and your competence. Let's move on to conducting a privacy impact assessment, or a PIA. As ISO 29134 says, the PIA is actually a tool, which means it's a checklist, but it's also a process. It's not something you just sit down at the desk, and go through it on one sitting. You have to go through the steps and bring that checklist along with you as you consult with the shareholders, with the process owners, with top management, and with the risk management group within your organization. Why is this required? Because the IRR and the law says that each organization should know what are the risks posed by the processing that they're performing. And the guideline on privacy impact assessment, which is advisory 2017-03, would help guide an organization through performing these types of assessments. Now, when should you do a PIA? Well, ideally, you do it before you launch a product, because as in the case of, for example, this vibrator, which you could control through your Bluetooth phone, it was too late to do a PIA because they found out that their violation of privacy caused them to pay $3.75 million to those who had purchased their vibrator. Or in the case of this toy maker in Germany, they had planned to sell these children's smartwatches, but because they didn't do a PIA, they didn't realize that those smartwatches could actually be violating the rights, the data privacy rights of these children. And so they were banned from selling any of those products. So doing a PIA, is described in this advisory 17-03. Primarily, it's these 2 steps. You identify the privacy risks, and then you address the risks through 4 possible strategies. Reduce the risk, retain the risk, avoid the risk, or transfer the risk. But take note that even if you transfer the risk, the liability is not transferred. Some key considerations, discussed in the advisory. There are 2 shoulds. You should undertake it for every system, and you should conduct it for existing and new systems, and 5 mays. So it actually, the last one even says you may skip it upon recommendation of the DPO. Preparing for the PIA means, first of all, you do your personal data inventory, or PDI. Then you identify the projects and processes and programs that act on that data. And finally, you conduct the PIA, which could include the following: identify the process owner, invite the shareholders, check for transparency, legitimate purpose and proportionality, and so on. So just to recap, the PDI contains the following elements: the data subject, the type of data, the legal basis. And legal basis is an important field, because if you look at the IRR, it says here, the following are the reasons or purposes that you can process personal information, and on the right side of the screen, for processing sensitive personal information. And if you do not find yourself listing one of these 9 as the legal basis for processing, you can't find yourself violating the law. You could find yourself doing unauthorized processing, punishable by 1 to 6 years. This is what a PDI would look like. In this case, we've done one for the following data subjects: the residents of the barangay and a child. And the name of the process is the Libreng Bakuna Program, or free vaccination. So you can see we've listed down here the elements collected, whether they're PI or SPI, the source where we got the data from, the purpose, why we've collected it, and here, of course, the legal basis. So it's mostly consent, but in this case, there's also for medical treatment, and in this case, there's also protection of life and health. Where do we store it? Who do we share the data with? And what are the policies? The important thing, of course, of doing the PIA is to identify the risks. And oftentimes, the risks are related to the information and the way we use it. When we collect the information, for example, there's the risk of getting the wrong weight of the child, which means the wrong dosage should be administered. So when we use the data, we have to make sure that we have accurate data to compute accurate dosage. When sharing the information, the risk is that the data may no longer be available when the doctor needs it. And so there's the risk of unavailability. And finally, when storing the data, there's the risk that someone might be able to access it, which would result in a loss of data in identity theft. So all of these risks could be listed down in a privacy risk map, where you have on the y-axis the impact and on the x-axis the likelihood. And the idea is, let's identify the risks so that we can control them. So once we have controls, then we can go about and reduce either the severity or the likelihood of these risks happening, which will then allow us to say, okay, we have created a relatively safe process. So here's an example of what the report would look like. For the vaccination program, which we are carrying out because of a DOH regulation, the benefit is high. The private risk was high, but we reduced it to medium by applying the following controls: organizationally, physically, and technical measures. So these measures, the OPT, are something that the NPC might come in and say, when they do an audit or an examination, what are the measures that you've applied to reduce the risks? And overall assessment is acceptable. Not necessarily true for all processes in this barangay. As you can see, the mayor has done a PIA for a suggestion box, and the assessment was unacceptable. For CCTV surveillance, and the assessment was unreasonable. And for dispute resolution, where the assessment was acceptable. So in an organization, you may end up doing 50 PIAs. I know one university that did 200 PIAs because they had 200 processes. And one bank even told me they did 700 PIAs. Once you've done your PIAs, you then want to document this in a manual. And that's why the next step is creating a privacy manual. What you have to understand is that, when you put out a privacy notice and it's read by your data subjects, it's really just the tip of the iceberg. Because the privacy notice is a promise. In order to realize that promise, you have to have internal documents, which are your policies on what data do you collect, how do you use it and disclose it, how do you allow the data subject to correct or access those data, what are your policies on storing and disposing of that data, and all the way down to your contracts and data sharing agreements. Because remember, when you make a promise to a data subject, it's not only you who has to realize that promise. All of the third parties and subcontractors to whom you expose that data must keep that promise as well. So if we take a look at all the documentation that needs to be in your privacy manual, it includes the following. What are the vision and mission of your privacy management program? What's the PDI and the data process flow? What are the impact assessments and the OPT or control measures? And of course, the data that you've entered there must be consistent with what's in your privacy notice, as you can see from the color coding here. And those consistencies must also extend up to the breach procedure, up to your policies. So there's really quite a lot of documentation that the NPC would expect to see in your privacy manual. The IRR does provide some assistance. There's actually some clauses in Section 44 which you can put into your contract with a PIP. And in Section 20 as well as Circular 1602, there are some bullet points that you can copy to put into your data sharing agreement. Of course, all those documents are for naught if they're not implemented. And so implementing the data protection and privacy measures means that you have to put changes in place into your policies, into your forms, into your procedures and systems. And that in itself is not enough, because you also have to make sure that your employees' behavior changes. And if those employees are from third parties, then you have to make it contractually binding. So all of these changes have to be programmed and synchronized, because it's useless to change the system unless you've trained your people on how to use the new system. And if your service provider doesn't know you've changed it, then they could be making errors as well. So these are multidisciplinary, complex projects that need to be done over an extended period of time. So that's why you need a DPO to lead this type of implementation effort. An implementation roadmap might therefore look like this. Of course, you have to get the buy-in of top management from the start, because they provide the budget, they provide the overall direction. The next thing that I suggest to do is to establish the breach team, because you never know when a breach will happen, and the breach team should be there to respond to the breach as quickly as possible. And then finally, appoint your DPO and organize this committee or task force. Once you have that in place, you create your PDIs, and that's the basis for the PIAs, which would then allow you to draft your privacy notices, which would then give rise to the change management efforts, the deployment of controls, the new policies, the new contracts, and the new data sharing agreements. So again, as I said earlier, all of this needs to be synchronized so that you're not stuck, making one change and having to wait for other things to catch up. Finally, you register with the NPC, and this is ongoing registration. As any time that you need to update your registration, it can be done online. The last step is to conduct an audit, because all of this effort would be wasted if they're not being properly implemented. And the audit effort gives you that comfort check to make sure that these controls, these notices, all of this training has actually taken hold. After all, as one DPO told me, all it takes is one person to commit a violation, and all of us will suffer the consequences, which is true. If one person does unauthorized processing or malicious disclosure, that could lead to loss of revenue, loss of customers. That could lead to loss of job or closure of the company. So even without worrying about the jail terms and fines, one should really start worrying about the consequences of a violation. Now, because in today's data-driven economy, privacy has become the proxy for trust. If you allow my privacy to be breached, then you lose my trust. And if you lose my trust, you lose my business. And of course, the opposite is true. If you show me how you respect my privacy, then I will trust you. And if I trust you, then I'll give you more business. So in order to avoid, that one person making that catastrophic mistake, the suggestion is really to do several types of training, including a half-day privacy briefing for all employees. When I was an employee with Microsoft, we would actually be required to take this privacy briefing every 6 months. And that would include taking an examination to see whether we've retained the concepts. It's also suggested that for department heads and process owners, they do an annual intensive session to remind them of what is a PIA, what are the current policies, of any new regulatory issuances, so that this can align with their strategic efforts towards doing new services, new products, anything that they plan to do within the next 12 months. For those that have been assigned to the DPO office, or who are for COPs, for example, they can do 2-day skills deepening, as well as the 5-day certification course, which I mentioned earlier. Last but not least, you need to know what happened, what to do in case there's a breach. Because, as the law says, the PIC should notify the Commission and data subjects when a breach has happened. And in fact, Section 30 says, if you don't do this, you can be punished by 18 months to 5 years in prison. In the IRR, it's been clarified that the such notification has to be done within 72 hours. So in order to help you prepare for such a breach and to prevent such a breach, the NPC issued Circular 1603, which is all about personal data breach management. It starts out by saying, there are 3 types of breach: confidentiality breach, integrity breach, and availability breach. Confidentiality breach guards against unauthorized disclosure. Integrity breach guards against alteration of data or inaccuracy of data. And availability breach guards against the loss of data. Usually we're talking about the permanent loss, not just a temporary or unavailability. Now take note, however, that the circular does say there are security incidents where an alarm is raised but nothing was lost, a data breach where maybe some data was stolen, and the third level, which is a breach requiring notification. So not all data breaches require notification. 3 criteria must be met. First of all, the data must be sensitive or may be used to enable identity fraud. Secondly, it was not encrypted, therefore it was truly acquired by an unauthorized person. And thirdly, it could give rise to serious harm for the data subject. Of course, one way to prevent serious harm, let's say a database of passwords were stolen, is to immediately reset the passwords once you find out about it. Notification should take the following form: the nature of the breach, what you're doing, and who the contact person is. This can be submitted in written format or electronically. It must be done within 72 hours. Again, if you are doing PIP processing, you do not have to notify the NPC, but you must notify your principal. You must notify the PIC. An example here is Sabre, which was breached, and they therefore notified some hotels that were operating here in the Philippines. And those hotels then notified the NPC and the data subjects. So it's important that your PIPs, whoever those are, and your PICs are aware of their obligations, so that if they suffer a breach, they can notify you, and you can then notify the NPC. Because in the end, it's all about accountability. You are responsible for any data that you have collected or are processing, even when you have transferred those to a third party, whether domestically or internationally. So we've talked about compliance. It's doing what's required. Accountability is really focusing on who needs to do these things and all the things that are necessary to be done. As we all know, it's Fire Prevention Month. And in order to comply with the Bureau of Fire Protection, they ask us install a fire extinguisher. And once you've done that, yes, you've complied. And yet we have, fires where people's lives are lost. And that's because we need to be accountable. No, we shouldn't just comply, we should be accountable. For fire prevention, for example, we have to train our staff on how to use those fire extinguishers. We have to make sure that someone's there 24/7 because a fire could happen at any time. And we have to give them apparel which they can use to protect themselves when putting out a fire. And all of this, of course, has to be drilled so that when a fire happens, they know what to do. That's the difference between just complying, which prepares you for a one-day audit, and being accountable, which prepares you for the 365 days a year when you need to make sure that these things are carried out. So again, thank you for your time. Thank you for your attention. Thank you for your interest in being accountable. I'd like to open the floor now for questions.
All right, thank you so much, Dondi. So while waiting for the questions, no, I actually have some over here. Um, Dondi, can you hear me? Sorry.
Yes, I can hear
Okay,
you.
cool. All right. Um, so this particular student actually tried the definition of the personal information and sensitive information, but Um, she can't seem to see the difference between them. Can you give a concrete example of personal information and sensitive information?
Yeah, sure. Hold on. I have a slide which says that. Uh, but in summary, personal information is anything that allows you to be identified. And sensitive personal information, which is something that allows you to be profiled or discriminated against. So hopefully you've seen this on the screen. PI refers to any information that when put together with other information can identify you. SPI refers to anything about your race, ethnic origin, age, color, etc., anything about your health, education, genetic or sexual life, and anything issued by a government agency, which could include SSS, TIN, and so on. So I hope that answers the question.
All right. Um, okay.
I mean, let me give you an example, maybe while waiting for the other questions. A photograph, can you be identified from a photograph? And the answer is most probably yes, especially if you're on Facebook, right? Um, you can tag a person and eventually, Facebook can identify who that person is with a very high level of accuracy. Now, on the other hand, if that photograph is colored, it could also be SPI because maybe it can show what color you are. Or if it was taken in a church, it can show what religion you are. Or if you're wearing a cross around your neck, or if it was taken, for example, in the house of a politician, all of these things can already refer to SPI. So the same photograph can be PI and SPI.
All right. So for, I think this is more of a reference now. What is the name of the training for DPO again?
Okay, it's offered by TUV Rhineland, TUV Rhineland. So there's the details on the screen. Uh, and actually, there's the contact person, Annalyn Lee. And the numbers are also there on screen.
Okay, so I guess for those who are interested. Okay, so uh, another question: how often do we need to submit a privacy impact assessment or PIA?
Okay. Um, privacy impact assessment is actually not submitted. Okay. You don't have to submit your PIA. And in fact, when we look at the registration, you don't even have to submit any documents. All that's required in registration, as we see here, is just a brief description of the system. You will need your PIA if somebody makes a complaint against you. And then the NPC will come and do an investigation. So be ready to show your PIAs, your control measures, if you have been selected for an examination. There are actually several ways that you can be selected for an examination, and these are listed on this slide. Okay. The first trigger for an investigation is if a data subject complains. The second trigger is a report from a whistleblower. The third one is if there's a news article and the NPC decides to launch an investigation. And the fourth one is what is called a random audit. Your name might just be pulled out from a hat and you'll be called to the NPC office and told that an audit or an investigation has been scheduled at your office. So once any of these four happens, that's when you'll be required to produce your PIA, your PDI, and your control measures.
All right. So for compliance, will there when will be the deadlines or deadlines?
Okay, the deadline for compliance was yesterday. as I mentioned, the rights were granted to us in 2012. Therefore, the obligation to respect those rights also arose in 2012. So there's really no such thing as a compliance deadline. Uh, in the end, the one who will judge whether you're compliant or not is the data subject. Because if they file a complaint, then you'll already be investigated. But let me bring you to this slide, which talks about the consequences of non-compliance. Right? If you're not compliant, then there's still the question of why are you not compliant? Or is it simple negligence or gross negligence? And if the answer is gross negligence, then that could lead to a violation. But of course, as I mentioned earlier, a complaint may lead directly to the finding that there was a violation. And if there was a violation, there are several things that can happen to you. You can be brought before the, here are the three things, okay? You can be issued a cease and desist order, meaning stop what you're doing, or you can be compelled to take an action. Maybe the NPC will tell you change your form, or change your procedures, or you can be forwarded to the DOJ for prosecution and imposition of penalties. Again, if there's a follow-up question, feel free to ask. I'm just trying to keep this brief, knowing that some of you may already have other plans, given that we kind of went over the allotted time.
Yeah. Actually, I have a bunch already. Um, okay, so another one is does the Data Privacy Act still allow profiling? What type of market research is allowed by the DPA?
Okay, I mean, to answer that quickly, if it's research for public interest, then it's allowed. So in other words, if you're going to be sharing your research findings for the public benefit, then that would fall under however, that only exempts you from obtaining consent. You are not exempted from securing the data and making sure that it's protected and that it doesn't fall into the wrong hands. If the research data that you have is improperly disposed or disclosed in an unauthorized manner, then you still could be liable for those acts. The only exemption that is given is the exemption from unauthorized processing.
Okay, so for the next two questions, I think this is more about the scope naman of the Data Privacy Act. So one participant actually asked, we are a company engaged in manufacturing of construction product with up to 280 employees. Are we required to register to NPC since we are acquiring some sensitive info from employee?
The answer is yes. The 280 employees is already met. No, that condition is already met. So yes, they should register.
Okay. The next one is we process data of Philippine residents, but our company is based outside the Philippines. Can we still register even if we don't have an office in the Philippines?
Yes, that has happened already. There have been, for example, consulting firms that are handling government systems that have registered. So by all means, no, please go ahead and register.
All right. Going back to process compliance now. Uh, it seems too long though. What happens if there's a breach while we're still doing the PIA?
Like I said earlier, you will undergo this investigation if there's a breach. because a breach will lead to possible investigation. Now, it all depends also on how the breach occurs. So please do read the circular on breach management. Um, Again, follow this flow chart. You know, gross negligence is if you have not even started the PIA, then if you have not even listed down the processes for which PIA needs to be done, then that's gross negligence. If you have at least started some of those, then you can argue that you're not grossly negligent, you are simply negligent.
Okay. So, bottom line, wag nang pasaway.
At least get something started.
Yeah.
Um, yep.
All right. Are individuals required to register? Doctors, etc.
Uh, yes, that's actually the subject of an extension. So if you type in the words individual PIC NPC registration into your search engine, you will come upon articles that say that individual PICs do have to register. So if you're a clinic, for example, dental clinic, processing dental records, which are sensitive personal information, then yes, you should register. I know of a school photographer. So a school photographer would usually be classified as a PIP, because they are contracted to take photos for yearbooks or at school events. And if this photographer has thousands of photos which are sensitive personal information because they show educational background, then of course he is also required to register, even if he owns, the photo studio by himself, doesn't employ anyone. He's still holding, thousands of records of sensitive personal information. Unless, of course, he has destroyed, all of the previous photos that he has taken, then he can say, that he falls below the 1,000 record requirement for registration.
All right. So, um, there are documents now to be submitted on March 31. I would like to ask, what are those documents?
Okay, again, the March 31 deadline is an annual deadline for submitting security incidents. Okay, remember when we talked about breach, we made the distinction between what is a security incident and what is a breach requiring notification. However, the good news is that only for this year, the extension was granted to July. So again, if you type in the words into your search engine, security incident report, NPC deadline, you will come up across articles that say that the deadline has been extended to June. But again, that is only for this year. Your 2018 report of incidents will have to be submitted next year by March 31.
All right. So, another question, can we register even before we have all the requirements available? Like we don't have a DPO yet or the manuals, etc.
Okay, the DPO is a prerequisite. No, you cannot register anything unless you first register your DPO. But once you have registered your DPO, then you can start registering your data processing systems, or the DPS. It's called the DPS registrations. The manuals, well, if you take a look at the requirements, there is no mention here of manuals. And that might confuse some people because actually, if you read the IRR does mention that you need to register your policies and manuals. That has been revised in Circular 1701, now which says that these are only the things that need to be registered. You don't have to register the manuals. Uh, You only need to register these data processing systems. Maybe later on this will be brought back, these existing policies or these certifications now that I've crossed out on the screen. But for now, registration only requires the name, details of the PIC or PIP, the DPO, and then this E and F, description of DPS and any automated decision-making operation. Let me explain, if I can, what is an automated decision-making operation. Essentially, this is an operation which is fully automated from beginning to end. Let me give you an example. Let's talk about a payroll system in a factory. What does the data subject do? Every day, he or she comes in, stamps their time card, or maybe even does a biometric scan. And based on that biometric scan, the computer already computes, the number of hours they work, the overtime, the holidays, the benefits. And at the end of the process, it puts money into an ATM and generates a pay slip. That entire process I've just described is fully automated from beginning to end. There's no manual intervention. So if you have anything like that that's happening within your company, whether it be for loan applications, credit card applications, student processing, job applications, if you have a process where end-to-end automation takes place, then you must register it with the MPC.
Okay. So last two questions. Is sharing of data through email or free online storage like Dropbox and Google Drive allowed? And considering that the files are password protected.
Okay, the recommendation is to encrypt any kind of personal data. And in fact, there's a circular that recommends 256, AES 256 as the level of encryption. Now, of course, that doesn't mean that that would never be broken. Who knows, maybe 5 years, 10 years from now, technology would be invented to allow that encryption to be broken. Therefore, ideally, if and when you dispose or erase that file, you also get certification that the cloud provider has in fact done so. I'm not aware if any of these free services would actually give you that kind of guarantee. Therefore, I cannot wholeheartedly recommend the course of action that has just been described.
All right. I guess for the last question and the most important of all, will you be sharing the presentation slides or kahit yung PDF format of your slides?
Yes, as I have placed on the closing slide, my email address is dondi@mapamail.com. So if you send me an email, just say your request for webinar slides. I'd gladly send you the PDF. Please share it with your friends, with your co-employees, with your family, especially if you have children, because it's their data that's going to be collected for the next 50 years. So do drop me an email, dondi@mapamail.com, and then I can send you the PDF.
All right. Thank you so much, Dondi. And for everyone, thank you so much for giving us your time for this webinar session. I hope you comply with what you have learned for tonight. And for other webinar sessions, we'll update you, and we hope to um, we hope to see you in the webinar sessions. All right. Thank you so much again, Dondi. Thank you so much for joining and giving us the talk.
Thank,
Good night,
thank you for
everyone.
giving me the opportunity. All right. Thank you. Good night.